Welcome to the Health and Government Operations voting session on Friday, February 11th. As you all know, as we go through the bills, wait, I got to hit escape so that I see my context. We will vote orally for yes on most bills unless otherwise announced, and raise our hands for no so that we get that correct. And I will read the names just to make sure that we get everyone's name. And if anyone has a problem, then just interrupt, okay? With that, we'll turn to House Bill 14, Delegate Cullison. Sorry, Lisa.
Again, I think that's with a withdrawal.
Oh,
I'd like to move to withdraw that, please, Madam Chair.
perfect. Is there anyone who needs? Oh, thank you. No, that was perfect. Absolutely perfect. Better than me. Is there any discussion about allowing the sponsor to withdraw this bill? All those in favor say aye. All those opposed, please raise your hand. And I'm opening my panels. I see no hands in the panel. The bill is withdrawn. House Bill 13, Lindsay.
As introduced, this bill requires that a person be debarred for 5 years from entering into a contract with the state following the issuance of an administrative order by the U.S. Department of Labor that finds that the person has violated a federal executive order by engaging in discriminatory hiring practices in the state. There are amendments that begin on page 1 of your packet, the Government Operations Subcommittee, that rather than mandatory debarment for 5 years, the amendment authorizes BPW to debar a person if the person has been found to have committed a violation of state law prohibiting discrimination in employment or has violated the federal executive order. It also clarifies that the bill is prospective in nature.
Delegate Rosenberg.
Thank you, Madam Chair. This bill, as Lindsay pointed out, as amended, would treat a violation of the civil rights laws of the state or the federal government with regard to discriminatory hiring practices as we do other civil rights violations and other violations such as fraud, so that the Board of Public Works would, upon receipt of a action by the Attorney General requesting debarment, the Board of Public Works would determine the length of the debarment after the final judicial act establishing a violation of fair housing, of fair anti-discrimination practices in hiring. And that debarment could be lifted upon petition of the party with the approval of the Board of Public Works. As amended, the bill was adopted unanimously by the subcommittee. And I would move the amendments.
Excellent. Is there a second?
Second.
Thank you. Is there discussion on this bill? Okay. All those in favor?
Delegate Krebs has raised his hand.
Oh, sorry, Delegate Krebs.
I just want to ask if the people that raised concerns about defining the practices, were they okay with the amended language?
The amendments were the result of discussions between the sponsor of the bill, Delegate Carr, and the representative for Enterprise Auto, or Enterprise Rental, which is what prompted the bill. So there's full satisfaction among the parties who appeared before the committee.
No, well, the ones I'm talking about is the Maryland Asphalt Association and the Maryland Transportation Builders and Materials. They're the ones whose written testimony I have. Just wanted to see if they're, if they were
no further statement from them.
Excuse me? What?
We received no further communication from them. They were invited to the hearings, so we assume they know what we did.
So they haven't, I didn't see how their issues were addressed, but wish they had clear. I mean, they're the ones that have the written testimony, and it would be nice to have their okay.
I presume there was the standard public notice of the work session. The agenda was posted.
Yes.
And they were not present. I believe that they are represented by lobbyist or somebody, and they know how the system works, but You'll have to think about what that means to you. Delegate Riley.
Thank you, Madam Chair. Yeah, I was just wondering, how would this affect, like, if there was a company and they had a subcontractor that worked through that company, would this affect the subcontractor as well, since they were doing a job for this particular company?
Only a party that had violated the law, which would be affected by the law. Only a party that had discriminated in its hiring practices would be affected, not some other party that had no involvement in the discriminatory acts.
Okay, so even though they were on the same job, they were hired by a particular company that had the suit on them, so the subcontractors would not be affected if it wasn't their company that did this discrimination.
Correct.
Okay, and a second question, and then I'll be finished, would be, what if it's a company that, I don't know that it would actually, because this is state procurement, if there would be any kind of companies that would have like franchises or anything like that, would it affect all the owners of the same business? Like they have separate locations?
I am certain that they could not evade the effect of the finding by the court would pertain to the company and its other subsidiaries. If it did, then they would be affected. If it did not, that is a decision that would be made by the trial court or the administrative board.
Yeah, so for instance, it's just like the letter of support that we got from the Legislative Black Caucus. They mentioned a particular company that, was in violation of it. So when that company is in violation and convicted as guilty, then it affects all the other entities of that same company in other counties and jurisdictions.
That if that were the holding of the trial court or the administrative body, the final action, which is then taken to the board. Yes.
Okay. All right. Thank you very much.
Delegate Carr.
Thank you, Madam Chair. Yeah, just to respond to Delegate Krebs's question, I did speak with the representative of the asphalt manufacturers, that other entity that sent those letters, and explained the bill to them and addressed all of their concerns. I think that's why we didn't hear from them anymore.
Thank you for letting me know that. I appreciate it.
Move the bill or move. Oh, sorry. Delegate.
Amendment. Oh, we
No,
did
they're
that.
raised hand, Madam Chair.
Oh, thank you. Delegate Kaiser.
Thank you, Madam Chair, and thank you, Mr. Chairman. I think in reference to Delegate Riley's question about franchisees, it's already the case, I believe, that with if you violate the federal executive order, that you get that debarment in that state, and it's already in the code that when the feds debar someone, we have to as well. So, I mean, that's current law, and that would presumably cover all parts of a company.
I don't think there's a question there.
Yeah.
Just an answer.
Yeah.
Okay. I see no further hands. All those in favor of the amendment say aye.
Aye.
All those opposed, no. I see no hands in the panel. The amendment passes unanimously.
Move the bill as amended.
Second.
Is there discussion on the bill as amended? All those in favor say aye. All those opposed, please raise your hand in the panel. Looks like it's passing unanimously. Okay. House Bill 55, Lindsay.
This bill authorizes the nurse anesthetist to prescribe, order, and administer drugs, including specified controlled dangerous substances. The bill designates a licensed nurse anesthetist as an authorized prescriber under the Maryland Pharmacy Act. A nurse anesthetist may prescribe drugs only in an amount that does not exceed a 10-day supply, only for an individual with whom the nurse anesthetist has, at the time of prescription, established a client or patient record, only in connection with the delivery of anesthesia services, and as the bill was originally introduced without obtaining approval from a practitioner with whom the nurse anesthetist collaborates. There are amendments that begin on page 4 of your packet that remove language in the bill that would have authorized a nurse anesthetist to prescribe drugs without obtaining approval from a practitioner with whom the nurse anesthetist collaborates, and also removes language that would have authorized a nurse anesthetist to collaborate with a podiatrist regarding the administration of anesthesia. They were considered in Health Occupation Subcommittee.
Delegate Kelly.
Thank you, Madam Chairman. There was a lot of good compromising going on with this bill. The amendment that the sponsor offered, which had unanimous support from the committee, and the whole bill came out with unanimous support, removed any opposition that was remaining from MedChi. What the amendment did was it reinstated the collaboration requirement and also took out podiatrists. So as the bill passed the subcommittee with the amendment, it was unanimous. There was also, I think, a letter in the file from Maryland Right to Life. I think there's confusion. I'll restate that the bill doesn't impact abortion at all, because we're talking about nurse anesthetists who are dealing with patients with whom they have an established relationship just during that 10-day course of medication they might need for like anti-nausea medication or something like that. So this shouldn't in any way impact abortion. With that, I move the amendments.
Second.
Is there any discussion on the amendments? I see no hands. All those in favor say aye. All those opposed, no. Please raise your hand.
Aye.
Thank you. Seeing no hands, the amendment passes unanimously.
Move the bill as amended.
Second.
Is there any discussion on the bill as amended? All those in favor say aye. All those opposed, no. Raise your hand. I see no hands. The bill passes unanimously. House Bill 166, Lindsay.
That's mine, actually.
Oh, yes, it is. That's my mistake.
That's okay. This bill establishes a Director of Dementia Services coordination position in the Maryland Department of Health to coordinate and facilitate communication relating to dementia services in the state. Beginning in fiscal 2023, the governor must include an appropriation in the annual budget to fund the director position and the Virginia I. Jones Alzheimer's Disease and Related Disorders Council. The bill requires the council to issue the state plan on Alzheimer's disease and related disorders by September 1st, 2022, and update it every 5 years. It requires the director to report its activities and recommendations in alternate years. The bill also removes the council's termination date. There are amendments on page 5 in your packet. Amendment number 1 is technical. Amendment number 2 alters the name of the council and title of the director, changes the staffing requirement to the director with assistance from the Department of Aging, and clarifies that the director's duties include coordinating the department's approach to addressing Alzheimer's and other forms of brain health, including through public awareness, prevention, and early detection and diagnosis, developing and monitoring implementation milestones and measurable outcomes for the state plan, coordinating public and private stakeholder partnerships, and applying for grants to enable the implementation of the state plan and its goals. Amendment number 3 specifies the appropriation amounts for the director.
Came to me.
Thank you.
Sure. So this bill and amendment also passed unanimously. Just a little brief description to remind you guys. First of all, personal opinion, I think this is one of the most important bills I've seen this session. I think it's so important. I'm so glad that we're doing this. It's going to provide a permanent director position that the amendment does mandate that appropriation. It's between $70,000 and $80,000 a year over the next couple of years. But it updates some of the language, uses language like related disorders, other dementias, things like that. It's modernizing it, but also really making permanent the staff position that's going to keep us moving forward in this space. So with that, I move the amendments.
Second.
Is there any discussion on these amendments? All those in favor say aye. All those opposed, please raise your hand. It's unanimous.
The bill is amended.
Is there a second?
Second.
Discussion? All those Oh, I see a hand. Delegate Kipke.
Thank you, Madam Chairman. Delegate Kelly, could you just very succinctly tell me like what good stuff is going to come out of this extra employee? I apologize for asking the question now, but I was
No,
absent.
well, and I did make a big spiel about how important it is. So, having this staff person reporting directly to the secretary, making this a permanent staff role, coordinating also with the Department of Aging, and they're going to be able to really move us forward in terms of dementia services and meeting the needs of the population of both those people with dementias in the state of Maryland, but also their caregivers. So it's really going to continue the work that we've been doing for, I think, since 2011, but take it to that next level of making sure we're doing all we can. Is that helpful? I think you're on mute.
Good, thank you.
I think we're ready, if there's no further discussion, to vote up or down on the bill. All those in favor say aye. All those opposed, please raise your hand. The bill passes unanimously.
That's not a no vote. I just wanted to see if we could do a sponsor amendment.
Oh, that's a good idea. Is there anyone, take your hand down, Delegate Krebs. Is there anyone who does not want to be a sponsor of this bill? You don't want to be a sponsor, Delegate Krebs?
I can't get my hand down.
Oh, okay.
There you go.
That's a good problem.
No, not being able to get your hand up is the better problem. Okay. Looks like the committee is all sponsoring this bill. That's great. Thank you, Delegate Krebs, for that good suggestion. House Bill 182, Lindsay.
This bill requires the Maryland Department of Transportation by December 1st, 2022, and annually thereafter to compile and manage a list of certified lesbian, gay, bisexual, transgender, or queer businesses in the state to identify and encourage outreach to LGBTQ businesses and attract their participation in state contracts. This bill was considered in Government Operations Subcommittee, and there are no amendments.
Delegate Rosenberg.
Thank you, Madam Chair. As described by council, this bill would require MDOT accessing an existing list. There no additional personnel would be needed by MDOT under the fiscal note. Accessing a list provided by the LGBTQ Chamber of Commerce as to which individuals or which businesses meet the requirements of the law. That is 51% owned, certified, operated, managed, and controlled by one or more LGBTQ individuals. And this is not a set aside, it is informative, and it would be for outreach and to be able to track participation of such businesses in the in-state contracts. And in light of discussion on the bill, I would just point out that people voluntarily add their businesses to the list. The LGBT community came to us and testified that they are in full support of this bill and therefore consider it to be in the interests of such businesses to provide for this certification.
Would you like to move the bill?
Move the bill. There is a hand raised.
And I'll allow discussion after the bill is seconded.
Okay.
Second.
Delegate Chisholm.
Thank you, Madam Chair. I did not vote for this in the subcommittee, but I do want to make a quick statement. And we had an opposition voice that brought up something about this bill that had absolutely nothing to do with the bill. It was kind of an outlandish statement. It was almost so insulting that I voted for it. But I just wanted to put that on the record because the reason I really didn't vote for this bill is it says to identify and encourage outreach. And I did ask the LGBTQ, I guess the president of their Chamber of Commerce, if he's already collecting this data, in which they are. And to me, they act almost like a regular Chamber of Commerce or even in the small business world, we rely on NFIB and they are always informing us of different opportunities or different aspects of the business. And so I feel like this is just an unnecessary bill. There's no need for a bill. There's no need for, because they're already able to communicate with the Department of Transportation and send them this information. And it's their job as a chamber to be encouraging and identifying for outreach purposes to let them know, hey, there was these procurement process in the state of Maryland through the Department of Transportation. But to me, I voted against it because I just felt like it was an unnecessary bill. Thank you, Madam Chair. Thank you, Mr. Chair.
Thank you, Delegate Chisholm, especially for disassociating yourself with some of the comments that we heard. Any other discussion? Okay. All those in favor of House Bill 182, please say aye. All those opposed, please raise your hands. Okay, I see Delegate Kipke, Delegate Riley, Delegate Shalega, Delegate Krebs, Delegate Morgan, Delegate Chisholm, and Delegate Saab. Are the people recording the vote done? Do you have the right tally? Richard?
Yes, ma'am.
Okay, I'm sorry, I lost your picture, so I didn't see your head nod until.
I gotcha.
Late. Okay, all right, you can take your hands down now. Thank you very much. House Bill 188, Lisa.
This bill is introduced alters one of the education and training pathways to qualify for a license to practice acupuncture in Maryland. Beginning on or after May 31st, 2026, an applicant will qualify for licensure if the applicant is both certified by the National Certification Commission for Acupuncture and Oriental Medicine and passes an examination determined to be equivalent to an exam given by the Certification Commission. In the Health Occupations and Long-Term Care Subcommittee, we voted on a simple amendment that corrected a typo. Right after we did that, I received another amendment that from the board that better reflects, I guess, what their intent was. And so with this amendment, it clarifies that the licensure requirements remain the same for acupuncture until May 31st, 2026. And then after May 31st, 2026, an applicant will be required to graduate from at least a master's level program or its equivalent and have passed the certification examination to become certified by the National Certification Commission for Acupuncture and Oriental Medicine.
Delegate Kelly.
Thank you, Madam Chairman. So just by way of further clarifying, what the subcommittee passed the bill and the technical amendment unanimously. The new amendment that we have before us, it rewrites sort of how the bill looks, but it does the same thing that we thought we were passing, which is pretty simple. It's basically saying in 2026. So right now you can either have the master's degree or have passed this certification exam. And most people, there's some crossover there, right? After 2026, you need to have both. And so that's what we thought the bill did. That's what the amendment ensures that it does. And with that, I pass the amendment. I move the amendment.
Second.
Is there discussion on the amendment? Seeing no discussion, all those in favor of the amendment say aye. All those opposed, no. Raise your hand. Seeing no hands, the amendment passes unanimously.
The bill is amended.
Second.
Is there discussion on the bill as amended? All those in favor say aye. All those opposed, no. Raise your hand. Looks that the bill passes unanimously. And moving on to our last bill. I presume that my staff muted me because you were hearing paper shuffling, or did it just get muted by accident at some point? Not just then. No, it wasn't the paper. Can you guys hear this? You can hear that. Okay. and I won't do that. I'll be careful and I'll mute myself. Thank you. House Bill 287, Erin.
This bill requires the Secretary of Health to be professionally qualified through experience or education in at least one of the following areas: health law or policy, healthcare facilities administration, health economics or financial management, government operations related to healthcare, or as a healthcare provider.
Delegate Penny Melnick.
Thank you, Chairman, and thank you, Aaron. The bill in subcommittee passed unanimous. And basically a question that may come up that was asked was, are there similar requirements in other for other secretaries? And the research showed that indeed the Secretary of Budget and Management has similar requirements. The Secretary must have experience in public financing, budgeting and management and fiscal planning. The Secretary of Disability also has to have extensive experience and knowledge in disability law, legislation, and regulation. The State Superintendent of Schools also, and the Secretary of Information as well. So this is done and it's needed. It does not affect the current administration. It is not personal. It is moving forward. I move the bill.
Second.
Is there any discussion of the bill? My discussion is that I noticed that we're requiring a master's degree for a massage therapist, but we're not requiring a bachelor's degree for the Secretary of Health. I know that was discussed, but it is sort of an obvious inconsistency in our thinking. I'm a little bit concerned about that.
It's actually acupuncturists.
Excuse me,
acupuncturists.
Okay, who are actually
For
putting
clarification.
needles in people. Okay, thank you.
So we have that is a valid concern, but we did discuss it, and the bill does require experience in health law or policy. It requires healthcare facilities administration, which could be a nursing home, a hospital, assisted living facility. It requires health economic or financial management, government operations related to healthcare, and it could be a healthcare provider, which is a doctor. So it's flexible, but at the very least, it requires experience in health.
Okay. Is there any other discussion? Okay, all those in favor say aye.
Aye.
All those opposed, please put your hand up. I see no hands. This bill passes unanimously. Does anyone want to be a co-sponsor on this bill?
Are you doing co-sponsors when there's no amendments?
Oh, right. Never mind. Thank you. No, it makes for more complication. This will get through faster if we just leave it exactly the way it is, if everybody's okay with that. Okay. Thank you. We will leave it pristine, Madam Chair of the subcommittee.
Thank you so much.
You're welcome. Is there any other issue that needs to be brought up before
We
say
skipped
goodbye?
House Bill 220.
What?
Yeah, 220 bill, we have not discussed.
Did I
I
skip
skipped it.
it?
Yeah.
The House bill.
Oh, I apologize. That's why I confused acupuncture with health yeah, okay. Everything becomes clear. Okay, that would be Lindsay.
This bill phases out the registered massage practitioner credential under the State Board of Massage Therapy Examiners. The bill prohibits the board from issuing an initial registration to practice as a registered massage practitioner on or after October 1st, 2023. And then beginning November 1st, 2026, an individual must be licensed by the board to practice massage therapy in the state. The bill also alters registration and licensure qualifications and subjects an individual who practices massage therapy without a license or registration to a civil fine of up to $50,000. The bill repeals the requirement that the board adopt an official seal and requires the board to maintain an electronic roster of individuals licensed or registered by the board. There are amendments that begin on page 9 of your packet that require a licensed applicant to have graduated from an institution of post-secondary education rather than higher education, retains the requirement that the institution be approved by MHEC, requires the curriculum to be both endorsed and accredited, and allows the accreditation to be only by an institutional accreditation agency recognized by the U.S. Department of Education. This was considered in Health Occupation Subcommittee.
Delegate Kelly. And
Yeah, Madam
there's
Chairman.
that requirement for education in that bill.
Well, yes, and I'm going to walk us through this a little bit because it changed some. With the amendments, which were supported by MHEC, MHEC is comfortable with this bill. This is, and this bill with amendments also passed the subcommittee unanimously, as did the amendments. The intention of this bill is to remove unnecessary barriers and really create a more efficient workforce. There was a lot of collaboration with the association and the board coming together to figure out how to do this. Our previous system was this two-tiered system where there were sort of two classes of massage therapists, and it wasn't really working, particularly for those folks in the registered category who weren't able to serve on the board or work in healthcare settings and had other rules imposed on them. So what it does is in 2026, phases all those folks who are registered into the licensed category by ensuring that they have met this higher level of standard that is now being imposed for educational requirements. But they're going to do that through a regulatory pathway that doesn't cost them anything and doesn't, it accounts for their time in service working, their work experience and their existing CEUs. So they are comfortable with that. But at the same time, moving forward, we're going to remove the requirement that there be an associate's degree and instead replace it with this 750 hours of training that's accredited in all those ways that MHEC required in the amendment. So with that, I move the amendment.
Excellent. Is there any discussion of the amendment? Seeing none, all those in favor say aye. All those opposed, no. Please raise your hand. The amendment passes unanimously.
Move the bill as amended.
Second.
Thank you. Any discussion? All those in favor say aye. All those opposed, no. Please raise your hand. Bill passes unanimously. Okay, I think that finishes the work of the day. Is that accurate? Okay. And there's nothing else anyone needs to bring up. Have a wonderful weekend, and I will see you all next week in person. Close
Absolutely.
and personal. Okay, looking forward to that on some level. Goodbye, everybody.